In Indian polity, we are going to discuss about Article 16 of the Fundamental Rights of the Indian Constitution. So, Article 16 is equality of opportunity in public employment. Okay, so Articles 14 to 18, which comes under the right to equality. This is the first fundamental right. Okay, so So there are important provisions under the Article 16. First provision is Article 16 Clause 1. So it provides for equality of opportunity for all citizens in matters of public employment or appointment to any office under the state. Okay, this is the first provision under the Article 16. Next provision is Article 16 Clause 2. No citizen can be discriminated against or be ineligible for any employment or office under the state on the grounds of only religion, race, caste, sex, descent, place of birth, residence. This is the very important provision under Article 16. So it generally talks about there is no discrimination on the point of employment under the state on the grounds of 7. Okay, so 5 grounds we already talked about in Article 15: religion, race, caste, sex and place of birth. And again here also 5 grounds plus 2 grounds, that is descent and residence. Okay, these 7 grounds are not allowed to discriminate people for the employment under the state. Okay, so there are some exceptions to this Article 16. So exceptions are Article 16 Clause 3. So Parliament can prescribe residence as a condition for certain employment or appointment in a state or union territory or local authority or other authority. So Parliament can prescribe residence as a condition. Okay. So according to this provision, our government, our parliament enacted Public Employment Act of 1957. So this is requirement as to residence, and this was abolished in 1974, but this is continuing in Andhra Pradesh and Telangana. Okay, only for the non-gazetted posts. Okay, and another exception to this article is Article 16 Clause 4. State can provide for reservation of appointments or posts in favor of any backward classes. Okay, so there is a provision for the appointment of posts in favor of backward classes. Here the state can provide reservation for the backward classes in employment. Okay, so this was the exception to this Article 16 4. And Article 16 4, there are subclasses under Article 16 Clause 4. Okay, and Article 16 Clause 5 is talks about a law can provide that a office related to religious or denominationally institution or member of its governing body should belong to particular religion. Okay, so if any religious institution is going on, that particular religious institution have some same religious members. Okay, so the governing members also should belong to the particular religion which is going in the religious denomination. So this was the exception to this Article 16 equality of opportunity in public employment. Okay, and the state is permitted to make a provision for reservation of up to 10% of the post in favor of economically weaker sessions. EWS quota 10% is there. Okay, so the state would notify from time to time on the basis of family income and other indicators of economic disadvantage. Okay, so by using that important provision, our parliament enacted 103rd constitutional amendment act 2019, and it says about the 10% quota to the EWS. Okay, so the persons who are not covered under the reservation of SC and ST, so whenever they have the below 8 lakh annual income and economic disadvantage, so they will get the 10% quota under the EWS. Okay, so coming to the Mandal Commission. In 1979, there is a Janata government, Morarji Desai. Whenever Morarji Desai was the Prime Minister of India, he appointed second backward classes commission. Okay, the chairman was BP Mandal. That's why this commission is famously called about the Mandal Commission. So he was a member of the parliament. BP Mandal, he was the member of the parliament, and on the basis of Article 340, he started to investigate. Okay, so what is Article 340? To investigate the conditions of a socially and economically backward classes and suggest measures for such backwardness and measures for their advancement. Okay, so on the basis of a 340 article, Morarji Desai appointed Mandal Commission. Okay, the chairman was BP Mandal. So this commission is a second backward classes commission, and there is a first backward classes commission. So 29th Jan 1953, this important first backward classes commission set up by the presidential order. The chairman was Kaka Kalekar. Okay, so we can call this as Kaka Kalekar commission also. Okay, so Mandal Commission and BP Mandal submitted its report in 1980. So it given some identifications and it given some important details. Okay, so he identified 3743 castes are socially and educationally backward classes. Okay, so 3743, it means 57% of the population excluding SC or ST. So 3743 castes are social and educationally backward. So overall 100% of the population, they constitute 52% of the population. Okay, so it recommended for the reservation of 27% of the government jobs to the socially and educationally backward classes. Okay, that is OBC. So total reservation of all SC and ST OBC should be 50% only. So there is no above the 50% for the social and educationally backward classes, SC or ST and OBC. Okay, and just he given some recommendations. Whenever coming to the VP Singh government, he declared, but 27% reservation not came into force due to some disturbances in the parliament. And in 1991, PV Narasimha Rao government was introduced these reservation, but it given some two changes in this reservation. First one is preference to the poorer sections of among the OBC in 27% quota. So on the basis of economic criteria. Okay, only poorer sections among the OBC, and reservation of another 10% of the jobs of poorer sections of the higher caste. Okay, so economically backward but poorer sections of higher caste, within higher caste there are the poorer sections of the people. So reservation of another 10% to the poorer sections of the higher caste who are not covered under the existing schemes of the reservation. Okay, so the famous case under the Article 16 is Indira Savani and others and versus Union of India in 1992. Okay, so this famously called as a Mandal case also. So on the basis of Article 16(4), which provides for reservation of jobs in favor of backward classes, on the basis of this article, Supreme Court given some guidelines to the Parliament. Okay, so Supreme Court rejected the 10% additional reservation for the poorer sections among the higher castes. Okay, and it upheld the constitutional validity of a 27 reservation for the OBC, economically educational, social and educationally backward classes. Okay, some conditions it given. So those are OBC reservation. So creamy layer should be excluded among the OBC reservation while implementing the law. Okay, and no reservation in promotions. only reservation for the appointments, not for the promotions. Okay, and reservations in newly are initially appointments, and there is no for the promotions. In case of any existing reservation in promotion, only valid up to the 5 years, that is from 1992 to 1997 only. Okay, and total reservation quota should not exceed 50%. Okay, and except in extraordinary situations it can maybe exceed. Okay, and every year this 50% reservation quota is following, and there is no above the 50% quota for the reservation. Okay, so there is a carry forward rule, and unfilled backlog vacancies is valid. So but this backlog vacancies should not violate 50% reservation rule. Okay, so if last year 100 seats for the reservation category, so 90 seats only filled. Okay, so the remaining 10 seats were the last year backlog, for example. Okay, so this year 50%, the 10 seats include in 50%. So this is known as carry forward rule, and there is no exceed the 50%. It means 50 plus 10 seats 60% is not allowed. So we should not violate the 50% reservation rule, but whenever the last year seats will include to the 50% seats in this year. So this is the carry forward rule, which was the guideline given by the Supreme Court. Okay, in the Indira Savani case. So it also given the statement that is permanent statutory body should be established to examine the complaints of the over inclusion, under inclusion in the OBC list. So it given the guideline is a permanent statutory body is important for the examine these reservations under the OBC list. Okay, so the government action to the Supreme Court guidelines is Ramanandan Committee. So Ramanandan Committee was appointed to identify the creamy layer among the OBC sessions, and it given the report in 1993, and this report was accepted by the government. Okay, so again National Commission for Backward Classes in 1993 was constituted by an act of Parliament. Okay, so 102 Constitutional Amendment Act 2008 given the statutory status to the National Commission for the Backward Classes. Okay, so according to 102 Constitutional Amendment Act 2018, it added new article, that is 338 clause B in the Constitution, because in the previous 338 article for the SC and 338 clause A article for the ST and 338 clause B, this is the new article by the 102nd Constitutional Amendment Act 2018. It added OBC in the Constitution. Okay, so important constitutional amendments under the Article 16. 77th Constitutional Amendment Act 1995. So this important Amendment Act added new provision in Article 16, that is Article 16 Clause 4A. Okay, so it empowers the state to provide for reservation for promotion in employment for SC and ST. This should be extended. Okay, so extension of SC and ST reservation, and this important new provision added by 77th Constitutional Amendment Act 1995. Okay, and important act is 85th Constitutional Amendment Act 2001. It provides consequential seniority to SC and ST with retrospective effect from June 1995 in case of the promotion for the reservation. Okay, so what is consequential seniority? Here consequential seniority means, so whenever the persons who are working under the government job in 2015, Okay, so there are general people and reservation people are working. So whenever coming to the reservation, especially SC or ST category, so whenever coming to the promotion for promotional reservation, so whenever they appointed in, or they appointed in 2015 or 14, whatever it may be, but in case of promotion in 2015, their seniority will take in consideration from the 13-14. As per the 2013-14, they will be in senior position. Okay, even they are appointed in 2015 also, but they will get the seniority in the previous years, like okay 2013 or 14. Okay, and 81st Constitutional Amendment Act of 2000. So this was a carry forward movement for the reservation. So it added new provision in Article 16, that is Article 16 4b. Okay, so if there is a unfilled reserved vacancies of a year, and there should be separate class of vacancies in succeeding year. Okay, that is whenever the backlog vacancies not filled, so these are the not combined in the 50% of the reservation. Okay, so there should be separate reservation in the following year. This is the 81st Constitutional Amendment Act 2000. Okay, and the next important act is 76th Constitutional Amendment Act 1994. Okay, so it placed a Tamil Nadu Reservation Act of 1994 in the 9th schedule. So overall it is giving 69% of the reservation to the low caste people, because there is a high population in under the low caste category. That's why it is giving 69% of the reservation to the people. Okay, so and this important act is protecting from the judicial review. Okay, and there is a article 16 clause 6. Okay, nothing in this article shall prevent the state from making any provision for the reservation of appointments or for the reservation for the jobs under the government for the EWS of the citizens, economically backward classes. On the basis of this article, our parliament enacted 103rd Constitutional Amendment Act 2019. So overall 10% reservation for the EWS quota. Okay, in civil posts and services under the government of India. Okay, so EWS quota not covered under the SC, ST and OBC reservation. Okay, that people also not comes under the EWS. Only who are not covering under the SC, ST, OBC reservation quota, those people comes under the EWS quota. Okay, so there are some exceptions to this reservation. So scientific and technical post exempted, so they should be qualified on the basis of their qualification and prescribed by the institutions. So there is no reservation for these posts. Okay, so a post would be in grades above the lower grade in group A of the service. Group A also excluded. Okay, and scientific and technical post qualifications should be allowed, not for the reservation, and they should qualify on the basis of the qualifications. Okay, and a research post also they should take a merit, and they should not allowed for the reservation. Okay, and the questions related to the exam point of view. First question is article 16(4)(a) added by which constitutional amendment act? First option is 85th Constitutional Amendment Act. Second option is 81st Amendment Act. Third option is 77th Amendment Act. Okay, so the answer is 77th Constitutional Amendment Act 1995. Okay, next question is article 16(4)(b) added by which constitutional amendment act? First option is 72nd Amendment Act. Second option is 42nd Constitutional Amendment Act. And third option is 81st Constitutional Amendment Act. Okay. So, Article 16(4)(b) added by 81st Constitutional Amendment Act 2000. So, it talks about carry forward in the reservation. Okay. Next important question in the exam point of view, the term consequential seniority which added in which article? So the option is 16(1), second option is 16(2), third option is 16(4)(a). Okay. So answer is 16(4)(a) article. In this article, our Parliament enacted 85th Constitutional Amendment Act 2001. It added consequential seniority in Article 16(4)(a). Okay.